it's designed for basically risk management. There are a lot of approaches to distributing the form, making sure the form is part of a contract. The penalties for failing to comply are really, really significant. And that's the issue. That's the issue. Some kinds of things that keep, your broker or manager up at night, especially given the fact that the EPA, the federal government agency that enforces these rules, is very aggressive in its auditing of companies. Companies, Long & Foster, for example, and if those of you who deal with, an agent from Long & Foster, you might have had this, discussion about whether or not the form needs to be in the contract or whatever. Long & Foster, about 15 years ago, was subject to an enforcement action by the EPA, and they were fined several $100,000. And so Long & Foster, their lawyers, rightfully so, in my opinion, as an attorney, one of the things we're supposed to do is keep you out of trouble. And so the Long & Foster attorney said, well, there's one way we'll make sure this never happens again. Put the form in every contract. And I understand that. As a risk management tool, I get that. And so you have a lot of different approaches. There was just another company in Anne Arundel County with whom I'm familiar. Very good company. Trained the agents well, as I know you guys are trained well. I mean, I can see just from the information that you have in front of you today that you're aware of all of these issues that are out there. And I know this company. It's a big company. The agents are well trained. The managers are all chosen, and they're experts, and they train and train and train. And yet, when this company was audited, the EPA said, produce the form, signed by the buyer and the seller, acknowledged by the agents, which, this is really the only part of the transaction in which you are actually involved, right? So that raises it to another level. And I know that they had these forms, just they couldn't produce them. For the EPA, they couldn't produce them, whether it was the fact that they weren't getting transferred from the agent's file to the main files. I mean, these were all transactions that had settled, in the last 2 to 5 years, and they pulled out the files from the main repository, and they could not produce the lead paint disclosure form, and they were facing fines, and the lawyer for this company called me and said, this is what we're facing. What kind of thing do we need to think about? And basically, they ended up settling, and it cost that company a couple $100,000. And it wasn't because they weren't doing it. I think they were pretty sure they were doing it. They couldn't prove to the EPA they were doing it. So no company's immune. You could get a call, Tim could get a call anytime saying, the auditors are coming tomorrow, and we need access to your files, and you have to produce the lead paint form. And if you can't, if you look down, I have, maybe that's what you're talking about, Sandy, somebody did it, I don't even know who did it, and every part of the form, they tell what the potential fine was. You've seen that? No, I'll send that to you. Okay. Somebody gave me a version of the form. You seen that?
No, I have one.
Oh, okay. Is that where it came from? And on every paragraph, on the left side in the margin, says what the fine is for violating, for not properly filling out, $7,500, $1,000, $5,000. And so these fines add up really fast, and no one's immune. There are a lot of approaches to making sure that these files are correct. So, really hard to stress too highly how important this is. And so Whatever your company's policy is, that's what it is. And that's what you follow. And there are a lot of ways to ensure compliance. But understand that's what the company's thinking about. And so just make sure that you follow whatever company your policy is. And that may lead to discussions with the agents on the other side of the transaction about how you're doing it. But by and large, it's the same thing when you deal with a Long and Foster agent. Look, this is my company policy. Let's work together and get this done. You usually work it out. So, any questions on the federal? Yeah.
So I think I understand what you're saying. Let me just recap. So it's not actually required. It's company policy made in a 1995 house to include that form, but there's no statutory requirement to include.
Yeah, and I said that, and we talked about that earlier. If you call the legal hotline, and ask, and I have to be honest, and I'm honest with the broker of Long and Foster. I call Nick D'Ambrosia and say, Nick, people are complaining that you all are doing this, and I understand why. But just give as a heads up, when somebody calls the legal hotline and the specific question is this form legally required? We have to give you the right answer, and the answer is no, it's not. I have to be open and honest about that, because it's true. But if this is what your company has said, this is the policy we are implementing to ensure 100% compliance, because the risk and the fines and the penalties for non-compliance are so severe that this is the best way we found to ensure compliance. Do it. That's your company policy. Follow your company policy. That's the answer we've given consistent.
And I'm going to kind of throw my own self under the bus because I want to just bring this
Yeah,
up.
fine, yeah,
I have said that if it is, 1995,
Yeah.
to simply cross through and write NA. And I've been told that that's not necessarily the correct thing to do. Should we still be filling it out? I didn't feel that was necessary. I want just every agent to think of, let's put it in there, and if it's not applicable,
No, I think that's okay.
2005.
I think that's okay. Just that it's in there, that you've addressed it,
Right.
because you can't fill it out so that it makes any sense.
Right.
If it's built 1978.
There's no spot for that.
So striking it and then making it NA, the agent on the other side is going to push back. Okay, then you have that situation, and you're going to have a conversation with the agent on the other side. It seems to me, especially if you're the listing agent, and the buyer's agent knows it's after 1978, so she doesn't include it in the offer, which a lot of buyer's agents will if they know, but a lot of buyer's agents won't, and then you as the listing agent have to make sure that it's part of the contract, right? That's can work either way, right? Isn't that true? So, but a lot of people are just uploading it as one of the great normal disclosures. Yeah. So there's a lot of ways to do it. I don't think that way is wrong. I really don't. But again, you're going to get pushback. I can promise you, you're going to get pushback from agents on the other side. And I just really don't have, I have to be very honest that I'm going to tell if that person on the other side is one of those people who just wants to be difficult, or the client does. I just got a call the other day, it was the client who said, why am I being asked to even look at this form? And it does, because it's not necessary, it's not required. And so even, it may not be the agent who's pushing back, it could be the client on the other side is pushing back. And those, you're really just going to have to deal with that on a case-by-case basis. Okay? But just, I'm always very sympathetic to the companies in this situation, simply because it's so serious. And again, the penalties are so severe and so significant that, I give companies a wide berth here for how best to comply. these things will take care of themselves over time, of course, probably not in our lifetime, but, you know, at some point, there will be so many fewer and fewer of these. And that's why I think Long and Foster has even loosened its grip a little bit. That's it. Any other questions on the federal law? This form from 2010. Yeah, we redid the form. We got, we really looked at the law, and remember there used to be two different forms, remember, one for sales and one for leases, because the EPA actually publishes two forms. They publish a sale and a lease forms, and the only difference is that last sentence in the first paragraph that talks specifically about the tenant. And we asked the EPA if it was okay to take all this information, which is virtually identical except for one or two things, and make one form for sales and leases. And they said sure, that it was okay. So that's back in 2010. We did combine the forms so that this works for sales and leases. So yeah, I thought we did a pretty good job. And again, every single one of these, disclosure, acknowledgement, agent's acknowledgement, it shouldn't surprise you that the penalties go up significantly in the agent acknowledgement section. Okay, so that's the other reason it's really important, because it's not just the broker who's facing these fines, it's you as well. Okay? Anything else on the federal form?
One question, just so I'm clear.
Sure.
So if the house is built after 1978, regardless of when it's built, just build the thing out and put it in every one?
That's what your company says.
Or
Or
cross through, put
right.
NA, built in 2005, and have them initial. I just want it in because I found so many little jaunts of time that were just actually missing. So
Even if you cross the line, have them initial all these things?
I don't even
No, I don't
think
think you have to fill it out.
Don't fill it out.
Say not
Cross through, NA,
Right.
built approximately 2005, initial.
Yeah, I think that's going to
Is
satisfy it.
everybody good on that? Have the buyer and the seller. Yeah, and if you know what, I'm really okay, and Tim, I want to make sure you concur with it. We're bringing this up in the last discussion. If the other agent really does give you a pushback, you can tell them it's company policy, but if they refuse to do it, let them know.
Yeah.
The agent refused to have buyer sign, just turn it in with the contract.
Is that effective today, a company policy, or do you want us to go back, if we have active listings, do you want us to go back and get all that into those listings?
I would say, I would try to, we've been pushing it when the files have been getting reviewed in the office, so I'm sure many of you have gotten those phone calls, but I would say try to go back and get it, when you can, get it added.
I got a question for you.
Okay.
I think it's the company you were talking about that got sued, but you didn't mention any names.
Yeah.
When they sent this federal form over to one of my clients, probably a couple months ago,
Okay.
but under the buyer tenant acknowledgement, even though there was no reports, there was no nothing, they still wanted my client to initial there.
Yeah.
And it says, if any. Well,
Right.
what is their reasoning for, do you have any clue why they would say their company mandates this?
Yeah, exactly what
Because
we're
they got
talking about.
sued.
Either or audited.
But if
and-
there's no reports, I mean, you're signing saying,
Well, but again, this form, for the federal form, remember, prior to 1978, the buyer's supposed to get this form whether or not there is any activity or any report, or whether there's even lead paint.
okay.
It doesn't matter. Okay?
I
This
just
is,
was-
this is simply a disclosure that there may be lead paint and that they're entitled to have an inspection. And that company probably is the company that faced this audit and failed and paid a significant settlement. Yeah. And this is, again, their reaction to that is, how do we make sure this doesn't happen again? It's expensive.
Sandy, what, you want us to do what now, which the professional, put it in all?
On every, I mean, just put it in, that's why it's on the list of your mandatory forms on the checklist, that's why it's been on there, and I know Valerie's been having a hard time collecting it, and everybody's like, it was built in 1995, I'm not getting that for you. It's because if we just have it as a habit, as it's one of the same 10 forms that you put in everything, every single contract, then we don't run a risk of making that mistake and having hundreds of thousands of dollars of fines that we can't afford.
And what do we
You
write on
know.
top if it's?
You can, I wanted to make sure with them that it's okay to cross through, don't just write NA, but built approximately 2005 or 1995 or whatever it does say on public records, and have everybody initial it. And then there's also the situations where the house was built in 1950, it's been gutted, right? House is like brand new. Fill out the whole form. Don't put NA on that, it still is applicable in my opinion.
It is, it absolutely
Yeah,
is.
okay. Thank you.
The date of construction, and you know, we get this sometimes, especially in historic areas, where if one wall is remaining,
Right.
the date of construction for the tax purposes, you know, is 1850 or something, you know what I mean? Because one wall, one foundation wall, some element of the original home is present, they will not update the date of construction. It'll be the original date. Is everybody aware of that? Right? You might have seen this. You have a lot of historic properties around here.
The
So,
form gives you a lot of out, it says seller has no knowledge.
and that's right.
Hey, and
That's
knowledge
right.
and knowledge,
So
but we're
fill
just
it
saying,
out.
if we
Right,
give
so
you
fill
the
it out.
opportunity,
Right.
that's it. We've
And
done
that
our job.
satisfies the
Really are.
EPS. You really are. And that's what this is all about. This is all about risk management here.
But we've just had so many people pushing back at
Right.
the office and then not complying, that I can't have it.
So you have a specific, you have a very consistent policy. This is what we teach all the time. Make it easy, make it consistent. Get the other agent to say, look, no harm, I would do this for you. All I'm asking for is an agreement.
I hope there's no more liquid lead paint out there, but in San Diego, we had a house like that where the father-in-law painted the garage door with some paint that was
Right.
left over from, I don't know when, but it had.
Probably got it from the Navy Yard.
Yeah, exactly.
Yeah.
I was shocked that it was still in there.
There are no
Wow.
consumer-based lead paint. That's since 1978. That's when they stopped selling.
Right, but I mean,
So,
I was shocked that it was still.
Yeah, there are some-
And it was in the 1990s, but it was.
yeah, I mean, it's hard to believe that a can of paint would sit around, but it was never, ever, ever open. Ever. You know, it's possible.
Yeah.
You know,
Anyhow,
and,
luckily they could replace the garage door, but I think the daughter was.
But remember, you know, for a long time, back in the 50s when, and especially even in the 40s, lead was put in paint in the first place because it was great. It was great paint. And most importantly, it stood up to washing. I mean, this was the 30s and the 40s were time when we used to wash our walls, remember? And part of the reason you washed your walls was for infection, you know, for, you know, polio, smallpox, I mean, really serious diseases, and people washed their walls. And lead was put in paint specifically because it made the surface impervious to the water and made washing walls easier. And it was highly touted for decades as a health issue, you know, a positive for your health because it allowed you to safely wash your walls. And it was only in the late 40s, very early 50s, the first person, by the way, the first person to recognize the health, the detriment to our health in 1951 was the health commissioner of Baltimore City. The first person in the country to identify lead paint as a source of poisoning of brains of young children. And that started then the campaign, number one, to stop manufacturing it, and then eventually to stop selling it. And so it started in Baltimore City. Okay. Anything else on the federal form or the law or the company's policy? Okay. The Maryland form is, again, some kind of confusion every once in a while. The first point I need to make is that this whole notion about 1978, remember the federal form is required for properties built before 1978. Maryland law applies to properties built 1978 or earlier. So the year of 1978, if it was built in 1978, Maryland law applies, but federal law does not. Okay, so be careful about that. Yeah.
Chuck, sorry, is it reasonable for an agent to rely just on the date of the tax record as the date we work from?
And yes, it's okay to do that. Yes, that's an excellent point. Okay, and the law says that. Okay, you don't have to do independent, God forbid. They're making you do enough.
Right, yeah.
Can you repeat that? What was just said?
Can you rely on the date of construction in the tax records? The answer is yes. For compliance purposes, the answer is yes. Okay? Now remember, the Maryland law applies to rental properties. Then what trips people up sometimes is it says rented or intended to be. Everybody aware of that? Now I don't like that language because how do you know? And so I would say, generally, unless a buyer, if it's currently owner occupied, and a buyer says, I'm an investor, I am not living here, and again, you'll know if they're not going to certify at settlement that it's principal residence, that puts you kind of on notice that this is going to be, or the buyer is intending for it to be a rental property. That brings it under the scope of the Maryland law. And we have a lot of these properties, investors are coming in, buying up a lot of these properties as investment and going to turn what was a principal residence, turning it into a rental property. And I suspect that a lot of people aren't picking up on that because at that point, the Maryland law does apply. Okay, so be aware of that.
So I've been saying that the Maryland law, anything pre-79, the Maryland law,
Yes.
I think we should still be disclosing it even to somebody who's gonna live in it. They might wanna live in it and for a year or two and then turn it into an investment property. And shouldn't we still be disclosing to them what they would need to comply with when they do change it to a rental?
Well, I think you can do that separately. To be honest with you, if I was going to suggest anything, I would suggest giving them that information separately. I don't think if it's not currently a rental property, and you have no specific information that is intended, that the purchase is being made with the intention of making it a rental property, then I would not. Because I just think that's too much at that point. I think you give that salary, say, hey, look, if this property was built before 1979, and you are gonna, or even in the future, anticipate converting this to a rental property, here's the information you're gonna need, and here's what you're gonna need to comply with. This is all about registry, because if it's not currently, then it's not registered, okay? And, this form doesn't work for that. You know what I mean? Because then you'd have to say, it's not registered. Well, it's not registered because it doesn't have to be. And then you read all the rest, and I think that's confusing to people. That's just
So
my,
the
that's just
case
my, off the
says
top of my head.
applicable is only if you're listing
If it's,
or selling
if it's rent,
currently.
basically, this falls on the listing agent. If it's currently a rental property or intended to be rented, then Maryland law applies. Okay? So now what you also need to know is, if you do any property management or rentals, you already know this, but right now, the Maryland program is mandatory for properties built before 1950 and voluntary for properties between 1978 and 50. That distinction goes away after this year. So beginning in January of 2015, every property built 1978 or earlier, that's rental, has to be registered, has to be in the program. Okay, no dual, no voluntary participation for properties built between 1978 and 1950. That goes away. So if you are,
January 2015.
yeah, so if you are either now dealing with or have under management properties built between 1978 and 1950 that are not registered, those owners, those landlords, have to register that program as soon as possible. And now, of course, registering is only the first step. It's all the risk reduction and the lead certifications that come later that become the biggest problems, okay? So it's not, registering also requires all the risk reduction.
And that's not the Maryland license or Baltimore County license.
No, that's separate. So Baltimore City, in those jurisdictions where you have to have a separate license to conduct rental activities, I don't think Anne Arundel has, I don't, Prince George's, do they? Prince George's? They have a rental license.
Napa has.
Oh, Napa does, okay. Okay.
Is that commercial rentals also?
No, I don't think so. I think those are residential.
Just residential.
That's what I think. Double check. I mean, I know Baltimore City is just a residential rental license, because it says it right on it. Okay? Yeah.
So the difference, I mean, I understand the difference between the forms, but with the federal, if you would just blatantly always put the federal one,
Yeah.
do we always, what's the purpose of the Maryland one then on top of the federal?
To protect tenants.
Okay.
The Maryland form is to ensure that owners, purchasers of rental properties know about the requirements of Maryland law for rental property, that apply to rental properties. That's what the Maryland does. That's what the program does, okay? Landlord, to ensure landlord compliance. And remember, about 3 or 4 years ago, we got a bill passed because under the prior law, if you were the purchaser of a rental property that was not in compliance, you bought the violation on day one of settlement, beginning at, on the day of settlement. You owned that violation. And there were a lot of brand new landlords, brand new owners of rental properties that were facing significant fines and penalties for the non-compliance of the property they just bought. And so MAR got a bill passed that gives new landlords, I think it's 30 days, it might even be 60, to comply. But they have to, first of all, know that the property is not in compliance, notify the Department of the Environment, and then bring the property into compliance within the specified time.
There are some houses that have very little lead, even though they were built before 1978.
There are.
And there's a testing and that you can do that is permanent.
That's right, it's called certified lead-free.
Yeah.
You all have heard me talk about this.
Certified lead-free. Now, I doubt that you can get that, it literally has to be lead-free, and that inspection is incredibly thorough.
Yes.
And if there's any lead, you're not gonna get that. So, that's pretty much reserved for total rehabs.
Well,
That's where you normally see the certified lead-free, because it's really hard to imagine taking a property built in 1930, 1940, and by just even replacing the windows, it's really on every painted surface. So it's really hard to imagine.
It may be, it's not necessarily, because some
Well.
houses that are older, the windows have been replaced, the doors have been replaced.
Okay.
And so at some points, I've had some where the only thing that was left was the sill below the entry door.
And then you can replace
And
that,
then-
Well,
have
if
it
you
retested,
can,
and
if you
you
can-
gotta let it
Exactly,
start.
and then
but
that lead-free is forever.
Certified lead-free is forever.
Yeah, so that's,
Right.
and that's really.
But again,
Keep the
that's
certificate with
that's
the property.
that's the golden ring. There's no
Yeah.
question about that's what you want.
Yeah.
But I'm saying that's hard, unless it's really a total rehab, down to the studs. Those are hard to get.
I was going to say, they have guns now that just go through
Yeah.
the wall.
Oh, yeah.
That's-
Yeah, if you
you're not
find
gonna get-
any lead at all, you're not gonna get
Replace
that.
everything.
And sometimes it can be
Yeah.
a beam, a structural
be
beam
almost
that has
anything.
lead in it.
Yeah.
And that happened to me a long time ago.
Yeah.
So it could be, well, we ripped the beam out and it was lead-free certified in a
That's
1920s
great.
house.
That's great.
And he had it forever and he used it as a rental property.
Right,
So he
that's,
was
that's
probably-
what you wanna try.
This question may be redundant, but just to clarify, so built between 1950 and 78, starting next year, if it is certified lead-free, does it have to be registered in the program?
No, that's,
Yeah.
you have the certificate, so that's the exemption. Right.
You only have to get it in the program if it does have lead.
Right. Well, no, you, okay, I
If
take
you
that
haven't,
back, I
if you
take that
don't,
back.
you don't have what he's talking about, lead-free
That,
certificate.
oh, yeah, yes,
Then you have to get it in the.
yes,
You have to.
yes.
But you're going to, out there to rent a prop, you're showing rental properties. And this is where we're finding our biggest problem. You're going out and looking at these rental properties, and then the other agent may not be giving you, hold on guys, the other agents may not be giving you the disclosures that you need. It's our responsibility to make sure that the right disclosures are filled out. And she says, well, the seller just didn't want to enroll it in the lead paper. Don't touch that property with the tenant. That's why I've been saying, I don't even want to see a rental come through on a house pre-1950 unless there's a lead-free cert. I'm going on the side of caution, but, I mean, because wasn't there an article that came out that said, even if, they have it in the program and the dust swipes are done every year, you have to prove that, you have to have a new, I know we're jumping to the rental part of it, but you have to have the new, every year they have to have, or when the tenancy changes, you have to have a dust swipe.
Not every year, it's on turnover.
On
Yes.
turnover,
Yeah.
okay.
Yeah.
So on turnover, you have to have the new dust swipe, so
Yeah.
you would want to have a copy of that before your tenant moves into
Oh,
the
you have
property.
to, oh, yeah,
Yes.
you have to.
But even on pre-1950 though, there was an article that came out that said that it put the responsibility, liability on the agents as well if there was, yeah. Okay.
I didn't write that.
Sandy, clear that you said if we have a lead-free certificate, that's
You're good to
different.
go.
But you said if the tenant leaves, we still have to
No,
do it
not
again.
if it,
No.
no, only if it's not certified lead-free,
Certified lead-free, you're good.
yes.
Do we have any special companies' names so we can?
Yeah,
Oh, yeah, a lot
Yeah,
of the
you
big
got- yeah, a
inspection
lot of
companies do
inspection
XRF. We'll give you a list of
Yeah.
them if you don't have them. I think we already have them in Dropbox, but we'll let you know.
yeah. Tim?
If it's in the program and the tenants, there is no turnover, then every 2 years, you still have to get the certification? That's my understanding.
Get something.
No, it doesn't really say that.
Okay.
It doesn't really say that, no.
Because the EPA sent me the form, they knew that 2 years had passed, and they said, you need to have a reinspection.
Under Maryland law, see, I don't, it doesn't really say that.
Okay.
I'll give you the specific, there is a reference to something, but it's not that. And I think people have misunderstood it, but I'll get the actual language to you.
Thank you.
Okay.
So, that's what.
Because an EPA doesn't have any authority over state law anyway. I'm not even sure how the EPA would know what Maryland law says. Anyway, so.
This is a Maryland law.
Yeah, this
That's
is
what's a
Maryland law.
Maryland law.
This is Maryland law.
Chuck,
Okay.
I'm a little confused. I thought the dust swipe thing, that's where I'm confused.
Yeah, but on every turnover, every time
Every
the tenant
single
turns
turnover.
over,
Okay, all
the
right.
landlord has to produce a new certification.
Okay.
Yes.
But that's
A
not
A
a
new
lead,
test.
that's not a
No,
lead.
once you're certified lead-free,
You got it.
you don't have to do the test on the tenant turnover.
All right.
That's the difference,
Okay.
okay?
Yeah.
But again, the vast majority of properties are not gonna be certified lead-free. It's just too hard. So the vast majority of your rentals, they're gonna have to be in the program. And every time the tenant turns over, you're gonna have to do the risk reduction, which is all the vacuuming and the phosphate wash and the HEPA vac. And the new risk reduction rules, beginning in 2011, require encapsulation, either vinyl or whatever, of all the surfaces that are rubbing together. So, it's hard, these tests and and then a new test. And then the test results have to be given to the new tenant with the booklet about keeping your family safe from lead. every time a new tenant occupies the property, yes.
Which is why we've been asking for on every single rental, if it's pre-1950, I told you for a period of time after, I know I read that somewhere, that there's some lawsuit, but it might have been in another state, I don't know. But, so I might have gotten it confused. But for pre-1950, when you all are listing the property, if your seller's like, oh, no, I'm not gonna enroll in that, you're not taking the listing. You are absolutely not taking the listing. And pre-1978, starting next year, we're not taking the listing if the seller doesn't want to comply. You can't touch it. Same as when, and now if they do want to comply and you can get a lead-free cert, that's great, you're done and off the hook, but you still, every time, if you're property management, you're turning over that property, I would suggest have the lead-free cert attached to your lease and in the file. Now, if you've done, and that's why we've been asking for proof of the lead-free, the dust wipes and making sure it's passing with your leases. It's very important.
Yeah.
Now, are the fines the same? Now, does Maryland do the fines like the federal?
No, it's worse. It can be much worse.
Why am I shocked by that?
The penalties for non-compliance, well, first of all, the potential liability on the landlord and potentially the property manager, if a child is living in this home and is poisoned by lead paint and sues the owner, the landlord, and potentially the property manager, there is no limit to the amount of damages plaintiffs can recover. It used to be $17,000. The Court of Appeals 2 years ago threw out that cap on damages. So right now, plaintiffs, and the plaintiff in that case recovered over $2.5 million in damages for living in a home in which he was poisoned by lead paint. And the court threw out the $17,000 damage cap. And so right now, literally, your liability as an owner and potentially as a property manager is unlimited.
That must be what I was reading.
Yeah,
And
that's
I thought
probably
it
what
pertained
you
to
were
not
talking
just
about.
property managers. I thought it pertained to and
Well,
for their agents.
No, I don't think the agent who first listed the property, I'm not sure that it extended to them, unless they had some active role in the actual management of the property. So I wouldn't say it extended all the way even to an agent, a listing agent who was not actually actively engaged in the management of the property. But a lot of the listing agents, of course, of these rentals are doing more than just finding a tenant. They are actually engaging in the property management by calling contractors up and doing all that, in which case, yeah, that liability would follow.
Is it better to be an LLC or privately owned?
Well, sure. I mean, LLC stands for Limited Liability Company. But I have to tell you, don't rely on that. That doesn't assure you that whatever damages are recoverable only to the extent of the assets of the LLC. I mean, that's why property owners put every single property in its own LLC. But lawyers see through that, same as we do with corporations, and actually it has a name in the law. It's called piercing the corporate veil. And if we can show certain elements, we can get to the personal assets of the owners of these companies to satisfy these judgments. So, yeah, of course, that's what you would do, but it's not a guarantee that, well, I'm still not coming after you personally on that $2 million judgment. I'm going to ruin your life. If I'm the plaintiff's lawyer, that's why it's important stuff. I'm going to ruin your life. I am. If I'm the plaintiff's lawyer and I have a $2 million judgment, this is important stuff.
I have one more comment about the white list. I helped somebody rent a place for several years, and they had completely remodeled it. And several years into the process, they found lead in the property, and it was found on the linoleum floor of the bathroom.
It didn't even have to come from there. It comes from the neighbor's house.
Actually, what we figured later was maybe that the
I'm
guy
quoting
that
him and he just said
had
right
it
here.
on the streets or something. Because that was the only place where it was found.
They're usually pretty careful, but, you know, it could come from the neighbor's house, it's in the soil. Especially if you're near a place that's been renovated recently, it's everywhere. It's in the soil, and, you know, you can't get away from it.
GRI class, the instructors were saying the liability is now being placed more on the actual tenant necessarily to show proof that they're changing.
It's not liability, yeah, the standard changed and how the law that addressed the court case, it changed the burden of producing evidence at these trials. So one of the elements of these trials is always, especially if it's in Baltimore City or in Annapolis or wherever it comes from, that this child, yeah, there was lead in this home, and yeah, the child is unquestionably got lead poisoning in his or her blood, but how do we know that the home is the actual source of that lead in that child's blood? How do we know that he didn't get it from his grandmother's house, or his playmate's house, or the daycare center, or the school? There are many other potential sources of that lead poisoning, of which the home is only one. And so it used to be the defendant's responsibility at trial to prove that there may be other sources, and now it's not. Now the plaintiff in lead paint cases has to eliminate all the other potential sources of the poisoning and limit that only to the home. So that's what the GRI instructor
Some were
was.
saying that the owners should maybe request that if there are children that are going to be living there, that they be tested before they.
Yeah, I've heard that before. Good luck with that.
I know, well, exactly.
Yeah, just send your kid over. I'm just drawing a little blood. Yeah, yeah. Good luck with that. Yeah, I can see all prospective tenants just turning their kids over to you. Drawing just a little blood, just not a lot. So yeah, I've heard that before. Yeah, like I said, good luck with that.
Is there any way I can actually pay a lawyer to have a signed document before the tenant moves in stating they're waiving the right to sue you against the lead-based paint?
Good luck with that too.
They're not doing that.
You know, do you ski? You ever go skiing?
Snow ski.
Anybody ski? Snow ski? Anybody snow ski? You read the back of your lift ticket? Right? You know, disclaimers and waivers, they never work.
Well, I mean, if they don't have kids, what do
They don't work.
You know, man?
Well, if they don't have kids, it's not an issue.
Yeah.
Is it?
No, but the science, I mean, there's no age limit, but the science is pretty clear now. I mean, we have decades of experience with this, and the science is abundantly clear. After really 7 to 9, I mean, this is, you know, our brain cells, but they're dead. You know what I mean? You can't hurt us. But it's the developing brain. You know, ours are the opposite of development. And so, and that's just the pure science. And the other thing is, and this is all real important stuff, of course, because the consequences are so devastating potentially. But let's be honest here. We've reduced the incidences of lead poisoning by about 95, 96% over the last 15 to 20 years. It is, without question, one of the most highly successful public health initiatives ever. Ever. It is. We used to measure these cases in the hundreds and thousands, and now we measure them in the tens and dozens. You know what I mean? We have so successfully limited the amount of lead paint in these homes, and really not quite eliminated it, but we're well on the way to really virtually eliminating lead poisoning. So don't overblow this, you know what I mean? We just follow the rules. The rules are very clear. You follow the rules, there's not going to be a problem. So we had 2 really bad ideas so far. You want to hear the third one? Oh, I just won't rent to families with children. I thought that was coming next, because that's what we always get. Draw blood, sign a waiver, and don't rent to families with children. All very good ideas. I will miss you.
Chuck, I got a question. I want to clarify what the agent's responsibility is. So in this Maryland form, in 6 months from now, it'll be that distinction, 1950, 1970,
Goes
go away. Okay, so projecting a year from now,
Yes.
if I were just a listing agent who had no prior relationship with the homeowner,
Yes.
they call me up, they tell me they're a private owner, they've been renting the house out for years, it
Yes.
was built sometime in 1975.
Yes.
And I make them aware of this. They say, I have no idea what you're talking about. I've owned this house for 30 years. I've been renting it. They had never registered with the program. What would be the steps that I should do prior to listing that current rental
Get
property?
it registered. Say, I'm not touching this property, neither will any other listing agent until you register the program, have all the testing done, produce to me evidence that it's in the program, and the most recent lead dust test results that pass, and then I'll put your property on the market.
So that's all required. There's no ability to say,
No.
we're out of the program. Okay.
Well,
So there's
again,
no
there
all-night
is
Friday,
still,
this on
again,
Saturday.
if you, but you know, don't touch that house. That's my advice. No.
So if we don't touch that house and the private person rents it, are they, as a separate question, is the private person liable?
The landlord?
Totally.
Landlord, yes,
Not just realtor. Like,
to the millions of dollars. If that person, if a child living in that home gets poisoned by lead paint and sues the landlord, that child can potentially recover millions of dollars in damages. Yes, absolutely.
To follow up on what Aiden said, if he goes out there and informs the seller or the owner, the landlord, of that situation, you go, or we help him get the lead-free certification, you don't have to register, correct?
Right.
Correct.
That was my
Wait, sorry, let me clarify. I meant when I said I'm the listing agent,
Yeah.
I mean they want to sell it. They don't want to re-rent
I
it. They're trying
understand.
to sell it.
I
Okay.
understand.
Still obligated.
But
to
it's
go
a
to
rental
old
property,
rental.
even, and you can't assume that the new owner is gonna have it as a principal residence. It's a rental property, when you take the listing, it has to be in the program. Now, if the purchaser wants to certify, right, under penalty of perjury, that they're gonna occupy it as their principal residence, and they do, and they're not lying, because that never happens, then that new owner can let that expire if it's not a rental property anymore, and the next time that comes up on the market, it won't have to be in the program, because it won't have been a rental property.
I guess it's
Does
just.
everybody understand that? And that happens, you know, people currently, this property's rent. And let's face it, this is gonna be a real problem, or, let me see, this is 5 years from now or so, when all the investors who are buying up all these properties, the wholesalers that are coming in paying cash for dozens of properties at a time, and converting them to rentals, when they wanna get out of that business, when the market comes fully back, now they're gonna flip those properties for a decent profit to people who want to live in them.
Right.
We're gonna see this. Okay, but those properties will have to have been in the program. And you're gonna have to have verified that, even if the buyer is going to occupy as the principal residence. Everybody understand that?
I'm a little.
It's because it's a rental at the time. That's what we care, that's only what we care about.
I guess maybe I'm a little, I just want to make sure I'm clear on this too. So I've always been, you know, when somebody's buying it, even, you know, there's nothing that they sign that says, I'm gonna purchase this as owner occupied or I'm.
Right, until the very end.
Right, until
Until
there's a
settlement.
closing table.
Well,
So we don't
no,
really-
actually, when they make when they make their loan application.
But we're not privy to that typically.
That's why I'm saying what I'm saying. You don't know. All you know is that this is currently a rental property
Which is why I've been.
when you take the listing.
Okay, so when it's currently a rental property, but I've been making sure I disclose all, you know, because somebody might live in the house for a year and then want to turn it into a rental a year from now. I've been telling them what the laws will
Yeah,
apply.
the law says, again, but I don't want you to have to do too much. You know what I mean? Again, the law says
I know we're not, but.
intended to be rented. So, you know, yeah, if you know, then the buyer should initial But this is the sellers, okay? So the contract just says buyer, if this is a rental or intended to be rented, right? You have to be aware of Maryland law. Remember that, paragraph 16?
Right, right.
As long as the buyer initials that, you're okay.
Right, that's right, it's covered.
You're okay, it's already covered.
Okay. But we need that for anything that's currently on
Yes.
the property
Yes.
moving forward.
Yes.
And after January, if they
Yes.
have to
Anything
be enrolled
built
in the program.
Or
Even if it's
1970.
February
Right.
of next year, they had to have been enrolled.
So now we gotta ask the people when we go to list their house, is it a primary residence or has it been a rental? And if it has been a
If
rental.
it is now a rental, if it's a current rental,
If we go there and the house is empty, we need to ask them, our responsibility is gonna be. I mean, I've been in properties where they've been empty and they call me up and say they wanna sell the property. And you show up there, I guess now we need to check with them to see if it's been a rental in the past.
It's current, it's not currently a rental.
That's what I'm asking. If it's an empty house, what's our responsibility?
Yeah, if it's empty, Chuck, it's not currently rented, right?
a leased residential dwelling, if it's leased, the time you take the listing. That's the definition, okay? So, if it's vacant, then no. But the buyer, no, the back tax records don't say it. Oh, yeah, it does. No, do not rely on the tax records for this. Because owners have notoriously lied to get the better mortgage and to preserve the homestead credit, illegally accepting the homestead credit, including some elected officials. We had the clerk of the court in Baltimore City had like 3 of them. 3 rental properties, and on each of them, he had principal residence, and he checked the box. And he was getting the homestead credit on the house in which he actually lived, and 3 rentals. And his excuse was, you signed so many things at settlement. I must have missed that. And my response is, it says under penalty of perjury, you certify that you are going to occupy this first when you apply for the mortgage, and second at settlement for the records that go to the state. So that's an excellent question, but generally speaking, you are entitled to rely on the public record. But I tell you, this one, if you are in that conversation, first of all, it's irrelevant to you. First of all, right? Because is there a lease? Yes or no? That's really the only question you need to know. Okay. So leave that other stuff aside. You could very well look at this and see in the record that it says principal residence, and it's not. And I had a neighbor in Baltimore City who was doing the exact same thing. It was just a dirtbag. This guy was. Thankfully, the property got foreclosed on, and now it's restored to a single-family residence. But I looked at the tax records, and it was principal residence. And I called SDAT, the Baltimore City Assessment Office, and I said, no, it's not. It's a 4-unit, it was an old house, built, chopped up into 4 rental units. I said, and he doesn't live there. And they said, well, we'll send out the letter again. Make them certified. Yeah, we'll send out the letter. And he certified that it's a principal residence, so we'll send the letter. I said, but he's already lied at least once. What's going to make him not lie again? So it's a big problem for me anyway. All right. Let's move on to advertising. And you guys have a really good, this is from the Real Estate Commission newsletter, okay? The Commission Check newsletter. Maryland Real Estate Commission cracks down on illegal advertising. So, first of all, you all should be reading this when it comes to your inbox anyway. It's great that Sandy's doing it for you, but if you're not getting this, that means the Real Estate Commission might not have a good email address for you. Or it got into your spam filter. So what you need to do is check with the Real Estate Commission to make sure they have a valid email address for you. And actually, you should already know this because of your CE acknowledgments, right? So you don't get certificates anymore. Like a day or two after you take a CE class, you get an acknowledgement from the commission that CE has been reported to them. If you're not getting those within several days after every CE class that you take, check your spam filter, make sure that Maryland Real Estate Commission emails are not going to spam, and if you're not getting them, make sure you have a good email address on file with the commission, okay? And then you will also then get the commission newsletter, which is chock full of important and at times troubling information and articles and what they call guidance, and to which I refer as regulation by newsletter. This, however, is a shot across the bow. This is what the commission cares about today. And they've told us that. They have told us that they are looking at your ads, that they're checking the newspapers, that they're checking the real estate book and the Home Buyers Journal, and they are filing complaints. It used to be that if they received or saw on their own an ad that does not comply with the standards in the law, that they would call you, maybe call the manager or broker and say, hey, we have a problem. Here was what the problem is. Here's what you need to do to fix it. Make sure the numbers are right, and the office number and your number, that your name and your broker's name are both meaningfully and conspicuously displayed. Do you understand? Yes, I understand. I'm sorry. Are you going to fix it right away? Yes, I'll fix it right away. Thanks, have a nice day. That's how it used to be. The way it is today is you'll get a formal complaint in the mail from the Real Estate Commission. They are not giving you the chance to fix it. They assume you already know what the law is and have chosen to ignore it and violate it, and you are subject to enforcement action. Not only you, but your broker or manager or manager as well, because they're the ones who are required by law to review your ads before they are placed. Managers are also complaints are being filed against brokers and managers for failing to supervise the activities of salespeople who put non-compliant ads out in the public. I can tell you that, I thought we were doing better. I was just in Frederick County last week, and I had a break between us teaching 2 classes, and I had a break. So I just grabbed the Home Buyers Journal off the shelf at the offices of the Frederick County Association, and I think, I'm just going to have some fun here. Let's see if I can find a violation. I have a sad life, so, pretty much what I do. In case you didn't know me, now you do. Sad, I know, but so I pick up the Home Buyers Journal, and I go, and the first thing I think is, wow, this is a beautiful home. I don't know what the front page costs anymore, but I'm sure it's a lot. And it was, again, beautiful home. Agent's name, I have to see her name, nice and big across, And then I was looking for the company name. Where's the company name? Where's the company name? Oh, there it is. Way at the bottom in the pretty much the smallest print possible. On the cover of the Home Buyer's Journal was a violation of Maryland law. And within 2 or 3 pages, I found another one. And 3 pages later, I found another one. And so I can tell you, there are significant problems out there. And so, you know, as this article makes clear, the standards are extremely clear. Your name and your company name meaningfully and conspicuously displayed. That means I should not have to struggle to find out what your company's name is, what company you work for, your phone number and the office phone number. Those are the rules. Okay?
I read through this, and it also says that your managing broker's name and number has to be displayed. That's a new one.
See, this is no, it doesn't. And I don't know why.
It says also your broker or branch manager's name and number must be displayed.
It doesn't actually say, the law doesn't actually say it. It's number.
It's what?
It's number, office number.
So basically, I think it's just
Okay.
saying broker number, but you're right, it's poorly
I'm
worded.
like, wow, everyone checks name on everything.
Well, you know, it's weird, his name was starting to come up on a bunch of some web stuff we were doing. Did you all notice that? It was either Realtor.com or I was like, did some law change that I don't know about?
No wonder she's
Yeah.
doubled her business.
No, Tim's name was coming up on you know, all the websites, I thought.
Tim doesn't want his name.
So the other issue here is for teams. But now you have teams in this office, and one of the things the Real Estate Commission is extremely concerned about is team advertising. And so if you look, if you look at the toward the bottom, it's first of all the name of the team or group can't include words that make it sound like it's the broker or a broker. Okay. Secondly, the commission has said that the name of the team has to be directly connected to the company name. Okay? And they have gone a step further, that last sentence there, directly connected next to the broker's name using the words of or with. Now that's not in the law, that's the Real Estate Commission's interpretation. And they are extremely, serious about this. I just saw an ad the other day for a team, and the team name was really large. And again, I didn't see the words of or with. And when I saw the company name was about 20% the size of the team name. It was a black and white ad. It was the Home Buyer's Journal, so in the middle, you know how that is, that brownish kind of paper. And the company name was sort of an outline, and the actual color, the fill of the name was almost the same color as the page, so it would look like a shadow, and it wasn't really dark outline either. And so it really had to struggle to determine the company name. And I happen to know the manager of this office, and I called her and I said, "Look, I'm not ratting anybody out. I don't turn anybody in." Said, "But this ad came from your office, and I think it's a problem. And I know this woman; she's an amazing manager, and she knows the law inside and out." And she said, "You will never guess what happened." This is a true story. And sometimes we know that, if Sandy says something, and, or Tim, and I know this, and we talk about this, I'm going to be giving a little secret. Sometimes you need to hear it from somebody else. Okay? So I'm here to tell you that was wrong. But she said she actually told this team. She said, "Hey, I don't think this is right. I think that the Real Estate Commission would consider this a violation." And the team leader chose not to believe her. And so she said, well, you know what, let's do this. Let's send it to the Real Estate Commission and see what they think, because generally they want you to do that, right? So she did. She faxed it over to Kathy Conley at the Real Estate Commission and said, can you give me your opinion about whether this ad complies with the standards as you guys have announced them? And 10 days later, that agent got a complaint form. The Real Estate Commission filed a complaint against that team for violating advertising rules. And the manager said, wait, what? We specifically called you so this wouldn't happen. Are you saying that because we sent this ad to you and asking for your opinion, you're filing a complaint against us?
Wow.
We turned ourselves in and now you're really? And Kathy Conley called, she said, oh, I don't think that's how it's supposed to work. Let me get back to you. Well, apparently it had gotten past her to the investigators, wrongfully, turns out, but it happened. And so she dismissed the complaint and thanked them for volunteering themselves as test cases. But these are the kinds of things that could possibly happen. Now, again, that all's well that ends well, and actually, maybe that's what that team needed to put the fear in them that these rules matter. Okay, so team name, company name, meaningfully and conspicuously displayed. It doesn't say the same size as or the same font, it doesn't. But it's a very common sense task. If I look at your ad and I know who you are, but I don't know what company you work for, and I can't determine those two things in about the same amount of time, it's a violation. It's an extremely common sense approach. So, there's no excuse. Every one of these violations is willful. I am convinced that you all, not you guys, broadly speaking.
So it's law to have the word of or with in there?
It's not law, no. It's their guidance. That's their guidance. And it's the Real Estate Commission who can take your license away. So what I always say is, as a lawyer, when I say, well, they can't say that, that's not the law, and somebody says, yeah, that's not the law, and I said, good, you be the test case, and you won't win at the Real Estate Commission level, but on appeal, you might win. Congratulations. A year and $15,000, $20,000 later, you win. Woohoo. So, you know what I'm saying? So they really kind of have us over, whether I agree or disagree. And trust me, when they put out this stuff and I say, this is wrong, this is wrong, this is wrong, or I see it is, I do tell them. We communicate regularly with the Real Estate Commission, and when they say stupid stuff, we tell them that. We tell them, this is stupid. This law doesn't say this. The same thing with, checking licenses of home improvement contractors. Same thing. That you're required. Does everybody know that? That was in another commission newsletter. You're supposed to be making sure that pretty much everybody that you recommend, if a license is required for that person to do that work, the burden is pretty much on you to make sure that that person actually is licensed. The commission has said that. So we should start getting in the habit of figuring out a way to do that. Even if it means, hey, when I put this list together, this person was licensed, but client, before you hire them, check. And that's an actual case. It was an actual RE/MAX agent from up in a different county, a different RE/MAX, but she put a home improvement contractor on her list, and he was licensed. 6 months later, his license expired, he didn't renew it. and a consumer used him and he messed up, and at the time he did the work, he wasn't licensed. The real estate commission filed a complaint against her for recommending an unlicensed contract. So these are the kinds of things that you're responsible for.
Can you put on the list the double check?
Yeah, that's what I just said. This person was licensed when I put them on the list. The list was created on this date. Here's where you would go to verify before you hire this person with the website. Say, go to this website and verify that this person is still in fact licensed. Yeah, I think that kind of disclaimer has to be on your lists. Yes, I do.
We had a case where the roofer had his license number. You know, you're getting ready to go to closing, you get all the receipts from this listing agent, and you look, you know, please make sure that their license number is on there. But then, after the fact, we went back to check the roofer who just put on supposedly this new roof with a 5-year warranty. His license expired in like 1998. And that seller, for hiring that license, we took him to mediation. For hiring that license, he put on a new $10,000 roof. So, because the guy wasn't licensed, and he wasn't.
And another one where we had, he actually like basically made up a license number. And he had it on his card, MHIC license number, blah, blah, blah. That was completely not his license. He just made up a number.
And you all know how
And
to
he put it on his business cards and his stationery and everything. He just
And
told
you all know how to find a contractor on the DLLR site, right? Everybody knows how to do that?
Everybody should know how to find these people, but this doesn't apply to just contractors. This is going to apply to title companies, mortgage companies, everybody that you recommend that is required to be licensed. This eventually is going to apply to all of them.
I actually had that happen to me when I was flipping a house, and the county actually went after the contractor, and guess what? They postponed it. 2 days before they go and tell them what's going to happen because he stole $50,000 from us, they drop the case. They don't get in trouble. Them contractors, there's so much. Check casesearch.com or whatever, man. There's some shady people out there.
There are. You've got to be careful. I'm surprised by that. They may have settled it. They didn't settle it when you say drop the case.
Yeah, what happened, they claimed they did 3 properties for us, and then they said they had a commercial license. Well, crap, they didn't have a commercial license. So it's all fake documents, every one of them.
What about, quote, the handyman?
Well, the handyman who accepts compensation for doing that work is in violation of Maryland law. If you look at the home improvement contractor license law, pretty much changing a light bulb for pay. If you get paid to do it for someone else, you have to have a license. When you look at the definition of home improvement in the license law, it's pretty much everything.
It's like 5 years in jail.
Yeah, well, up to, yeah. I mean, there are.
A handyman has to have a license.
Like I said, well, first of all, it's not Maryland. Let's face it. Let's be honest here. The people who want these licenses are the people doing the work. Don't blame the General Assembly. If I'm doing this work, I want a license requirement. I actually ask for it.
What are you talking about, putting doors on?
Because it puts everybody else out of business.
We need to cut
Look,
grass.
they wanted this. They wanted this. This was not imposed on them. Let's be real clear about license laws. License laws are anti-competitive, and the people in the industry ask for these. They do. I worked in this law. I know how it works. The people in the industry want these licenses to keep everybody else out. That's what this is all about. So don't blame the government for this. This is not the government imposing. This is people who are doing this work trying to keep everybody else out. That's what this is all about. Be very clear about that.
So if you just need a couple home improvements, as you're saying, hang a door or, fix a crown molding or something, you can't hire a
You can do whatever you want, but that person is violating the law. And you have no recourse if that person comes in and instead of putting that crown molding out, destroys a wall and and, you know, breaks something in the house and is completely incompetent, you have no recourse.
If you're doing it for your own house,
You
let's
know?
just clarify, maybe
No,
if
I'm
you're
talking
doing
about
it.
you do it for somebody else for money,
Right.
it's, comes under the license law. That's all I'm saying.
Can we come back? I'm having a hard time with this. So there's the law, then there's the real estate commission's recommendations, and I'm having a hard time. We can't be responsible to read every law that's out there, and there, you've said that the guidance from the commission is not consistent with the law. There are a lot of other things.
Sometimes it's not inconsistent, just adds additional requirements, for example.
But I mean, to me, then we're responsible for complying with the law,
Yes.
and you're stating we're responsible for complying with the real estate commission's recommendations.
Yes.
And we can, in either case, we can be fined, based on not.
$5,000, yes, and lose your license, yes.
Okay.
That's what I'm saying. That's why it's important to read this, that's why it's important to have meetings like this, where you get this information that maybe you haven't gotten before.
Yes.
This is a very active real estate commission. That's my overall theme here is that, yes, you are responsible for a boatload of law. I was going to pick another word, but, you know, a boatload of law. And you can't possibly know all of that law. I agree with that. It's a trap, yeah, and it concerns me. That's why we're always on the real estate commission to knock it off, because they're setting traps for you, and it's not fair. And we're constantly telling them, you know, quit making this stuff up. You're making it harder, and and some of it doesn't really protect consumers like you pretend to, you know, it doesn't. Like this, with or of, I mean, come on. But you know, they have wide latitude to interpret the law, and they interpret the law through issuing of this kind of guidance in these newsletters. And the best we can do is tell you about them and make it as easy to comply. Now, this really, ABC team of XYZ company, that is not hard.
I agree with that.
So you know,
What I'm having a hard time understanding then is, that's easy. Some of the other stuff in there makes it more difficult. If you want to put ABC company of ABC brokerage, broker's name and phone number, team leader's name and phone number, that gets hard to put on an advertisement when you add all those things in. And my concern is that the real estate commission is requiring more things on this piece of paper than the law actually requires.
well, again, I'm going to double check that name of the broker. I don't think is true. I'm going to double check that.
Maybe?
Well, no, the name or the team name, company name, meaningfully and conspicuously displayed. Your phone number, office phone number. That's what you should focus on.
We're talking
Those
about
four
this
things.
sold cards, we're talking about any kind of mailer.
Advertising is anything. Advertising is is your business cards, your pens, your frisbees, your refrigerator magnets,
You said
everything.
4 things. I'm sorry, I missed the 4 things.
Your name, your company name, meaningfully and conspicuously displayed, your phone number, the office phone number.
So the realtor out there that has his name on a sign and you call it, it only has his name as the real estate name, but only one phone number.
It's a violation.
And it goes to his cell phone.
It's a violation.
And it says on there, if you need my broker, here's the number. So they're
Well, the commission hasn't formally addressed phone trees. You know what I mean? If it's a totally automated robot that no human being ever answers, and the consumer's always given the opportunity to reach the broker without going through the agent, I suspect the real estate commission might actually approve that. But they haven't in any formal
this is
way.
a cell phone number. And you
Well,
have
then
to
it's not. If
investigate
it's a
it.
cell phone number and I pick it up,
You can't go around.
you can't go around. The whole point is so that consumers can get to your broker or manager without going through you. Because I have a problem with you. I need to talk to your broker or manager. So that's the reason for that other number being there. So yeah, it has to be there. Yeah, it does. They're violations. You see them all the time. And this is what the real estate commission's, you know, their frustration right now is how easy it is to comply and how many violations they still see.
So for those little temporary open house signs that you get from Merrill Corporation that say Remax, and then I have my name put in, it doesn't say Remax leading in.
It
so
has
that's
to
not
be
in
your company
compliance.
name, your name, your company name.
So I
And
can
if
cross
you
those.
use, technically it says, if you use a phone number, you have to put the office phone number. So if you just have your name, but if you have your name on it, it has to have the company name on it, yes. Yes, no, the full company name, right. The full company name, especially with the franchises, because you'd have to identify the specific.
Yesterday from the Board of Realtors, and it just says open house with no name on it.
Well, if it's
Saturday
nothing
open,
more than
Sunday
a
open.
directional sign with an arrow, then no,
Then I'm good.
then it's okay.
My other ones, we can't.
You know, just a sign with, that says open house this way with nothing else, that's okay.
But if it has our name.
But it has your name, it has to have your company name on it as well, the full company name. Okay, let me finish real quick with a couple of new laws. And actually, we think the governor is signing these today, so real important stuff here. First of all, one that is sort of in other parts of the country, to have local governments use their powers of eminent domain to actually condemn mortgages. Not the properties themselves, but the actual mortgage that secured the property. And in which case, the holder of the mortgage would only be paid whatever, you know, the value of that as a condemned property is. And then a private company would come in and refinance the loan, supposedly help to save, you know, the homeowner. The biggest flaw on this business model was that they were only targeting performing loans. So while, yeah, the homeowner might have been underwater, they were current on their payments. They weren't, you know, they weren't facing imminent default or foreclosure. And these properties weren't even on the market. They were just simply underwater. Well, that defines a lot of people, you know, who bought any time in the last 7 years. It's possible that you might be a little bit underwater, maybe coming back. It doesn't mean you can't afford it. Doesn't mean you're not making your payments. It just means you can't sell right now without taking a loss. So this is a bad business model. It sounds good if you say it fast, you know, but it's a terrible idea. So we got a 2-year moratorium passed on this practice in the state of Maryland. So if you hear about it or read an article from another state where this is being touted as a way to save underwater homeowners, just know that it's not coming to Maryland anytime soon. Another bill that we got passed, obviously, big deal for us, was to address that pit bull case from a couple years ago that imposed liability not just on pit bull owners, but landlords of tenants who own pit bulls were also held to be strictly liable for damages caused or injuries caused by the dog. The new law that is actually already in effect, okay, does 2 things. First of all, it restores landlords to the standard of liability that existed before the case was announced. And that decision came down, changed landlord liability. The law undoes the case and restores landlord liability to a simple negligence standard. So in order for, and it applies to all dog owners, all dog breeds, by the way. So the current standard is landlords who, if you don't know that that dog is dangerous, then you're not liable for injuries caused by that dog. And it really not breed specific. Now for dog owners, the standard of liability for us has changed a little bit. It used to be that a plaintiff, if my dog bites somebody, I have a cockapoo, he's not about to bite anybody, but if he did, in the old days, the plaintiff would have to show that I knew the dog was dangerous, and I would have to, you know, kind of like introduced evidence that I didn't know. As of today, if your dog injures somebody, the law will assume you knew the dog was dangerous. And you have to go into court and prove you didn't know. Do you understand the difference? So the burden is now on the dog owner to prove that they did not know the dog was dangerous. So that's the new standard of liability in Maryland for dog owners. Okay? And that really will be fun to watch because I can imagine like parading some character witnesses into court. You know what I mean? Like the neighbor's kids and all. Oh, son's a great dog. You know, never heard him flee. He must have been tormented or taunted or, you know, provoked somehow. So that's what these cases are going to look like from now on. Another bill, very important, especially in the property management area, is interest rate on security deposits. So we've been complaining for years that we are paying tenants 3%.
PG County's 5%.
It's 4 in Prince George's County, but I think that Prince George's County is probably going to change their law. But it's 4 in Prince George's, it's 3 in the state of Maryland, and we've been trying for 6 years to get that reduced and then make and tied to some kind of variable index, so that we never have to deal with this again.
Yes.
And so we finally got that passed. And starting January 1st of 2015, the interest rate on security deposits is the greater of 1.5% or the U.S. Treasury daily yield curve rate on the first day of the year, the first business day of the year.
Or the U.S. Treasury rate on the first day.
Okay, now we're going to put something out on this. You don't have to, it's the U.S. Treasury daily yield curve rate as of the first business day. You can get this on any, you can Google that, you can get it in 30 seconds. It's in the Wall Street Journal, every business, the Baltimore Sun, the Capitol has it in the business page. It's a standard on January, so whatever the first business day, I don't know what the second is, but I can tell you right now, it's lower than 1.5%. So for the foreseeable future, and I'm talking about the next 2 or 3 years at least, it's going to be 1.5%.
So that's retroactive. If you've got somebody that's been in
No,
property
it's
for 4
not
years.
retroactive. No, it's the new rate that's effective as of the first business day of January, or well, it's effective January 1.
So leases that start after January.
No,
Oh, okay.
no.
Just making sure.
It is what it is. So if you have a lease currently, first of all, if you have a lease that goes back to the 1990s, you could still be paying 4. You got it. When it changed to 3, so you got to pay 4 when the rate was 4, 3 when the rate was 3, 1.5 when it's 1.5, and you have to separate these out and do specific different calculations, historically what the rate was at the time. In those blocks of time, that's the rate that you apply. I talked to our technical person at MAR, and I explained briefly to him what would be involved in a calculation like this. First of all, it's a relatively simple calculation because it accrues twice a year, so it's not hard to do. It's simple interest, so it's not compounded, so you always go back to X if X is the security deposit. So I asked him that, and he said it doesn't sound like it would take him more than a couple days to design a calculator in which you could say the tenancy started on this date, ended on this date, the security deposit is X, put those values in, and that this thing can calculate what you have to give back to the tenant. So we're going to do that. We're going to put on MAR's website a interest rate calculator, and we'll do that work for you. And he also said, do you want to show the work? And I said, yes. So you not only get the amount that you have to give back, but you'll see the work, the calculation that was done that supports that. So we're going to do that. Okay? And then every year, we'll update the rate. When that rate does rise above 1.5%, then we'll just have to update the calculator to make those different calculations.
Can the interest be kept on, say you have a $1,500 deposit, $3,000 of damage when the tenant moves out? Can you keep the interest as part of?
Of course. That's part of it. Of course. Yes.
What if on the, is it legal to write on a lease instead of 3%, put on their market interest?
No,
Market?
that's no. The law
Violation.
says it's 3%. It doesn't say or as otherwise agreed to.
Okay. Maybe they
The law is the law. Okay. There was, let's see, interest rates, pitfalls. Yeah, those are pretty much the big bills from 2014. So I have to give that, kind of disclaimer here. In my opinion, until Maryland law changes, okay? If I'm a landlord and it depends really on the actual ordinance and how source of income is defined, and it's a little different. You go from Howard County to Montgomery County to Frederick City, you know what I mean? It's not exactly the same language, but generally speaking, it includes housing vouchers like Section 8. But if the reason I am not accepting this tenant has nothing to do with their income, that my reason for not participating in Section 8 is because it's a voluntary program and I'm choosing not to participate because I don't want to comply with the property standards. I don't want to subject the property to the additional inspections. That's the reason I'm not accepting this tenant. In my opinion, that's not a violation. That's Chuck's position at this point. But I have to tell you, it gets more complicated because you have a whole other analysis under fair housing law that's called the disparate impact analysis, which says that basically if you make a business decision that on its face doesn't have an impact on the protected classes, right? In other words, you're saying, I'm not accepting you because you're Section 8. That would be a clear violation. But if I said, well, no, that's not the reason I'm not accepting you. I'm not accepting you because I'm making the choice to not participate in Section 8. But the impact of the decision falls disproportionately on members of the protected class. Does everybody follow this? Mm-hmm. That is itself a violation. It's called the disparate impact analysis. So if my neutral business decision has a disparate impact on protected classes, statistically they show that I could potentially be found to have violated fair housing. So I'm saying my analysis is this as of today. But if the disparate impact analysis gets approved by the Supreme Court, and HUD has adopted it, it's being challenged. If the Supreme Court says, yes, this is a valid test, my answer is going to change. Because by definition, that decision to not participate will have a disparate impact on members of the protected class because of their source of income. So in Howard County, it will be a violation. So my analysis is going to change. Also, if Maryland adopts source of income statewide as a protected class, the way that bill is written, Section 8 becomes mandatory. You don't have that choice anymore. And that'll be an easy answer, which some people don't mind. Some landlords don't care. They don't mind. Some landlords I talk to love Section 8. They love their tenants. They love that the check comes on time every month. They actually, and they've had good experiences with the inspectors. Now I've heard the opposite. I've heard inspectors, Section 8 inspectors saying that tree has to be trimmed. You know, stupid stuff like that. But, so I hear both sides. Yeah.
Actually, I had somebody once say they did not want to use Section 8 because Section 8 at some point was tardy in paying. There was a delay of some sort, and they were worried about their mortgage payment.
Yeah, well,
So
that's a valid issue. I think that's more rare. It might be some other issue.
Yeah, I think
To my experience, that's kind of rare, but I don't do it, so, you know, I can only.
Chuck, if I'm a listing agent for a rental property, as part of that process, we get a full credit report for the applicant, we get them to fill out all their income information, all that stuff. Is it appropriate to take that full package and email that to an out-of-state owner so they can review it? And has all that information, are they free to have access to all of it?
Yeah.
Okay. Do I need to cross out social security numbers? I'm giving a lot of very personal information that could lead to identity theft. I want to make sure that nobody.
I would be careful, but they are the owner, after all.
Yeah,
You know?
but nobody can come back
So-
later and say, I didn't have a right to share it with some third party.
But they're not a third party, they're the owner. I mean, I would never do it. I would always take all that personal stuff, driver's license numbers, social security numbers, check account, routing numbers and account numbers at the bottom of checks. All that stuff can be used for identity theft. Before I put any of that stuff in the mail or in an email, I would be very careful to protect it. Yes. Yes. That's just for your benefit. Because
How would you protect?
by scratching it out, blacking it out.
Flat it out with a marker copy.
Well, then there's no such email. If you got an application.
Well, you can,
No,
yes,
you
you
have
can.
the facts there,
Yeah.
you just don't have their
Yeah.
personal, that.
There's always ways to do it.
No, if an application come over from another company, and I filled out the application for a rental, okay? My email, scanned it and emailed that information.
Oh, well, that wasn't the question.
To the Bailey property.
That wasn't the question. The question was to sharing it with I'm the manager and I'm
Yeah,
sharing it with the owner. Your question is, if you're the tenant, you're representing the tenant, and an email came, and the application is all done online. First of all, if you're not secure, if it's online, I say do it online, or scan it, either way. I wouldn't be sending those emails. Now, if they're not secure, you're risking putting, if you put anybody's personal information in an unsecure location, including a typical email, you're taking a risk. There's no question about that. The hackers they're out there. They're killing us. I mean, not a week goes by where we don't write an article about some security breach somewhere. You know, it's frightening.
As groups of protected class, for instance, I go out and I list a guy's house for rent, put it up for rent for him, and he says, look, I only want families. And he doesn't want groups. Groups being two guys, you know, whatever the case may be. Are we allowed to say that somebody?
Unrelated individuals are not protected. No. Familial status under federal law is defined as families with children. So you cannot discriminate against families with children. In Maryland law, it's marital status, which is the status of being either married or unmarried. Okay? But there is nothing in your state or federal law that prohibits you from that. Ocean City, it's a very common practice in Ocean City. There are entire developments in Ocean City that say we do not rent to more than two unrelated individuals at a time. Or we rent only to families. We don't rent at all to unrelated individuals, at all. That is a common practice in Ocean City, and it's perfectly legal.
I just had a neighbor tell me that since I put in there that no groups.
No, that's not a
violation.
No, it's not true. Okay. Anything else? I know you have other stuff to do, so I think I've overstayed my welcome. Thank you very much.